I am going to deliver on the admissibility of evidence before international courts from a more general perspective, but we are going to arrive, to put it in more specific context of the international criminal justice. Let me make a kind of disclaimer. I'm not an original criminal lawyer. My field of expertise is public international law. Yet, for several years now, I've been dealing with international criminal law. When we deal with this issue, so the question of evidence before international courts and tribunals, I believe, it is worth first to define what I understand as evidence. So I take this term as a tool for the reconstruction of disputed past events in the context of judicial trials. I believe this definition is broad enough to be accommodated not only for the sake of today's meeting. In that regard, of course, it is inevitable to define the judicial trials. When I speak today of reconstruction of this past in the context of judicial trials, I mean, international courts and tribunals. And in that regard, I would say that, the perspective of international courts and tribunals would be a bit different, at least from that of a domestic judiciary. Basically this goes in line with an international character of those judicial bodies. According to one of the most eminent international judges, Manley Hudson, there exist no general rules that have been adopted to constitute an international law of evidence, and international tribunals are usually free from limitations of national tribunals in that regard. Apart from special provisions, international tribunals claim and indeed exercise complete freedom in the admission and evaluation of evidence in order to arrive at the moral conviction of the truth of the whole case. A tendency in the practice of international tribunals is to accept all possible means by which the disputed facts could be proved. I believe one of the best reflections of that position was provided almost a century ago. Here in the slide, the first quotation comes from the Permanent Court of International Justice, Mavromatis Palestine concession case, and then the court declared itself at liberty to adopt the principle, or I dare say even principles, which it considered best calculated to ensure the administration of justice, most suited to procedure before an international tribunal, and most in conformity with the fundamental principles of international law. Of course, there is this temptation to offer special treatment to newer international tribunals of a criminal character, which should be distinguished from the traditional interstate litigation. In contrast to other international judicial bodies, evidence would play a very prominent role in the decision-making by international criminal courts, as they are entrusted with determining the individual's criminal responsibility and not the liability of states. It is also worth underlining that, also the international criminal tribunals, and in that sense, there would be no difference between international courts of general character and those of criminal character, would both suffer from difficulties in securing state cooperation and having access to evidence. The other perhaps complicating factor is the fact that when assessing the situations comprising the the international crimes. International crimes are most often committed during the armed conflict, which makes well, the access and the possibility to reach information on those crimes even more difficult. When we deal with international criminal responsibility, then well, the distinction between formal and substantive rules gets blurred, and well, the other quotation I allowed myself to include in this presentation comes from well, a famous lawyer, Sir Hersch Lauterpacht, educated first in Lviv, then moving to the United Kingdom, and basically alluding to the impact of formal and procedural rules on substantive justice. And when we deal with the admissibility of evidence before those international courts and tribunals of a criminal character, there opens a question, of course, of which tradition those judicial fora are going to rely. We've got, of course, different traditions or several traditions. Where to simplify the issue, one could, of course, well, distinguish between well, the civil or continental model and inquisitorial model and the common law tradition, or any of its variations. And in that regard, well, of course, those different traditions offer different models, and well, there are different roles, different settings of the of those actors taking part in the procedure, in also collection, production, and assessment of evidence. When in a common law criminal trial, a judge is to filter the available information that might be offered to a jury by deciding on its admissibility, the role of the judges in the continental inquisitorial model is quite different, totally different than a professional judge, not a jury in civil system, is to try the facts. Now, this would of course have impact on the proceedings and how it works. The mixture or blending together different models would come. It is of course possible, yet there is a price to be paid for this. When dealing with this issue of admissibility of evidence before international criminal courts and tribunals, I would like to present today briefly the development of those rules, and first to share some thoughts, or well, to bring to light the relevant practice of the international military tribunals established in the aftermath of the Second World War, then to rely on the regulatory framework and the practice of those ad hoc tribunals established by the United Nations Security Council in the 90s of the previous century, and finally to look at the situation before the International Criminal Court. And with regard to international military tribunals, those tribunals established after the Second World War, one can say that the statutes of those Tokyo and Nuremberg military tribunals referred only cursorily to evidentiary issues. You've got here, well, the Article 19 of the Nuremberg Charter reproduced, and accordingly the tribunal shall not be bound by technical rules of evidence. It should adopt and apply to the greatest possible extent expeditious and non-technical procedure and shall admit any evidence which it deems to be of probative value. Almost the same, almost the identical formulation might be found in Article 13, letter A of the Tokyo Tribunal Charter, yet there was one important addition providing for the admissibility of all purported admissions or statements of the accused. When it comes to the operation of the ad hoc tribunals, the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda, those two tribunals also adopted a pretty lenient and flexible admissibility rules of evidence. When we look at the provisions of the statutes, respectively Article 15 of the Yugoslavian Tribunal Statute and Article 14 of the Statute of the Rwandan Tribunal, the judges of the International Tribunal are free to adopt rules of procedure and evidence for the conduct of the pretrial phase of the proceedings, trials and appeals, and the admission of evidence, the protection of victims and witnesses, and other appropriate measures. Well, the judge made rules provided for admission by the trial chambers of any relevant evidence which they deemed to have probative value. At a later stage, however, the chamber could exclude such evidence. The adopted rules of evidence were considered unique, not by being simply a hybrid of the civil and common law system, but by replicating neither system. It was submitted that the International Tribunal for the former Yugoslavia first could not be too strict about the criteria for the admissibility of evidence. Accordingly, it was considered that the inclusion of technical rules would only encumber the judicial process. For that reason, the tribunal's chambers had a broad discretion to decide on the admissibility, relevance, and probative value of evidence. I believe it is, well, the appeals chamber decision taken in Aleksovsky case that is worth mentioning now. And then the judges stated that the purpose of the rules was to promote a fair and expeditious trial, and trial chambers must have the flexibility to achieve the goal. Then the judges made also underline the difference between, well, the common law system with a jury deciding on a guilt, and the continental model with professional judges. And well, accordingly, also mentioned that, well, it is the judges who, by virtue of their training and experience, may or were able to hear the evidence in the context in which it was obtained and accord it appropriate way. Thereafter, the judges may make a determination as to the relevance and the probative value of the evidence. A compromise, again, between those two different traditions had to be reached in the negotiations leading to the adoption of the Rome Statute of the International Criminal Code. Again, well, in a pretty simplified manner, but well, I would say that, well, within the system of predominantly adversarial character of the procedural system, well, the rules on evidence, well, would be of origin which would be perhaps belonging to the different tradition. Well, basically the idea is about squaring inquisitorial law of evidence into a predominantly adversarial system. Now, of course, those the evidence collected needs to be or are to be then used in the course of the proceedings before the court. So again, there is a price to be paid by those by the blending together of those two traditions. When we look at the Rome Statute, then what is of particular interest for us when dealing with evidentiary issues is Article 69, and in that regard, I would say that the negotiators succeeded in sending different or perhaps diverging or at least mixed signals. When we start, the whole provision includes altogether 8 paragraphs, yet I decided to concentrate on those which I believe are most important for the sake of our today's deliberation. When we pay attention to Article 69, paragraph 3, then it is for the parties to submit relevant evidence relevant to the case, but the court would have the authority to request the submission of all evidence that it considered necessary for the determination of the truth. The latter sentence could suggest, the inquisitorial model, yet, not in its purest form. When dealing with the admissibility of evidence, of course, what comes to our mind should be the paragraph 4 of Article 69. Accordingly, the court may rule on the relevance of admissibility of any evidence, taking into account inter alia the probative value of the evidence, any prejudice that such evidence may cause to a fair trial or to a fair evaluation of the testimony of a witness. This gives flow for the court's role to be played in assessing the admissibility of evidence. There are also some exclusionary rules on evidence, and they are mentioned in paragraph 7 of Article 69. Accordingly, evidence obtained by means of a violation of this statute or internationally recognized human rights shall not be admissible if the violation casts substantial doubt on the reliability of the evidence, or letter B, the admission of the evidence. The admission of the evidence would be antithetical and would seriously damage the integrity of the proceedings. With this very provision, I would have some doubts, especially when we look at the role of human rights to be played in the applicable law as defined in Article 21, paragraph 3 of the Rome Statute. Be that as it may, what one can say on that is definitely not the automatic mechanism for excluding the illicitly obtained evidence. And I believe one of the early decisions, the earliest decision by the International Criminal Court, the Lubanga decision, the trial chamber 1 concluded that evidence obtained in breach of national procedural laws, even though those rules may implement national standards protecting human rights, does not automatically trigger the application of Article 69, paragraph 7 of the statute. This provision is merely to be considered lex specialis when compared with the general admissibility provisions set out elsewhere in the statute and represent a clear exception to the general approach. So literally taken, the general approach is, well, to have a broader approach we know from the general international law. A kind of reflection of that line of reasoning or confirmation is to be found in Article 69, paragraph 8, barring the reliance on national rules dealing with the admissibility or well the admissibility of evidence under the domestic law. So the general approach by the Rome Statute or by the negotiating parties is to eschew most of the technical rules on admissibility in favor of a system of utmost flexibility. Well, there are, of course, those three cardinal criteria on the admissibility. So when assessing, well, those are to be taken into consideration. Yet, for example, when looking at the Bemba case, I would have, well, some serious or obvious doubts on, well, combining, well, the approach taken at the trial stage, providing for the prima facie declaration of admissibility, and well, then the critique offered to that position at later stage in the by the appeals chamber. And that brings me, as my time is running out, well, this brings me, well, to the price. I mentioned that this blending together of those two traditions comes at a price. On one hand, of course, we are to pay attention and allow for, well, flexibility, but at the same time, the price to be paid is, well, to also include the fair trial requirements. So this is not only the time factor that is to be taken into consideration. This is not only about managing the judicial proceedings. For that reason, I decided to include well, the reference to the famous quotation by Robert Jackson in one of my previous slides on the poison chalice. In the context of the Nuremberg trials, Jackson warned against, well, the objection of achieving too much at once. This, I believe, is also this also holds true, well, almost 8 years after the time Jackson made his warning. Yet, to conclude, I would like perhaps to provoke, well, with a kind of general conclusion that, well, at least at this cursorily defined level, there is this tendency, there is this general trend that international tribunals, including also international criminal courts and tribunals, would have the power to decide for themselves what is admissible as evidence. And well, in fact, this brings me to the role of the court as the final arbiter for deciding the admissibility of evidence, well, submitted in the course of international proceedings. Thank you very much for your attention.
Дуже дякую, пані професоре.
Thank you very much, Mr. Professor, for your introduction to our meeting, for raising very important questions and issues, and for this informative presentation. I think that this emphasis that international courts, that a lot depends on decisions of international courts, and they have more opportunities to allow evidence, to admit evidence which should show the truth at the very end. I think on the other hand, it is quite positive information, but on the other hand, it is very important that you've emphasized this price, that admissibility of evidence is especially important in these systems. In these systems of justice where the juries are used, where jurors have to decide whether the person is guilty or not. And there, this defense of the defendant seems to be more important than in these processes which are considered by courts, professional courts, prepared and trained to do that in order to be able to evaluate all the evidence that have been submitted for their consideration. You've also mentioned in your presentation about Lauterbach. And we should emphasize that he's from Lviv, just like Raphael Lemkin, and these are two very fundamental lawyers. Both Lauterbach, he created the list of these war crimes, and Raphael Lemkin is the author of the concept of the genocide. And in this respect, I would like to say that we have a very important book, and I think that every lawyer, international criminal lawyer especially, should read. That is the East-West Treaty, and this is the book that is extremely important. This is the history of these two lawyers from Lviv, and this is also the history about their creation of this concept. And these are very important concepts which are now used in the criminal international law. And now I would like to pass the floor to Dariusz Sheritsky. He will talk about more practical issues, a very practical issue, especially in the context of a war in Ukraine, which is one of the which provides lots of electronic evidence. And this issue is very important, how to evaluate such electronic evidence, whether they are admissible or not. And this issue is very, very practical on the one hand, because we know that we have lots of such electronic evidence which have been created or collected in the process of war in Ukraine. But also, I also remember that when we considered Kosovo cases, there it was a huge problem, and there was a very intense discussion between judges from different countries whether it was allowed to admit such evidence as a YouTube video or a phone image. And Dariusz Sheritsky will tell us more about that.
First of all, great honor for me to be here and talk to you. I follow closely the Sunflower project. I'm delighted with the mission statement and the way the mission is carried. So I think as much as we all want to help Ukrainian colleagues and Ukrainian people, Sunflower project is a good example of initiative which is really meaningful. Why do I have a courage to talk to you about electronic evidence? You know, I've been a judge in Poland for 20 years, and after that I joined international judiciary in Kosovo. And already that time we had a lot of digital evidence presented in the courtroom. We judges, international judges, were coming from different systems, different legal cultures, and it was visible. It was very difficult to find a common denominator. Therefore, I think that meetings like this one play a very important role in shaping a proper judicial practice. You know, that time when I started my work in Kosovo, I would be happy if I could familiarize myself with the work presented by Professor Kshan on admissibility of evidence, that and also by Anna Adamska-Galant. I hope her book about vulnerable witnesses in international courts would be soon available in Ukrainian language. So, as I said, we had very often a situation that the piece of electronic evidence was requested by the party to be introduced into the body of evidence, and judges were surprised, and judges refer to some concepts that they were not really familiar with, just only because they wanted to preserve some conformity with international standards. So next slide, please, Anna. Do we really need conformity with evidentiary standards, with international commonly acceptable standards? In a domestic court, we should care about compliance with domestic legislation. But when it comes to international crimes, and when it comes to crimes against humanity and war crimes, we have to keep in mind that the judgments would be scrutinized not only in the country but also by international community. So to gain international recognition of domestic judgments, it's necessary to follow some common understanding of fair trial and common understanding of fairness in admissibility of evidence. And we have to keep in mind that while hearing war crimes, we are preserving history. We are documenting the facts that present the history, and the evidence that we collect in our cases should be admissible, should be useful also for proceedings in any other countries that can initiate a war crime trial. It happened in Kosovo. It happened that evidence from Kosovo courts were presented in trials in the Netherlands and in Germany. So that's important, that this conformity is preserved. But first of all, judges do not think like procrastinators. Judges do not think about, appreciation and recognition of the judgments. Judges, first of all, think about safeguardings of fair trial and fairness of the proceedings to the best possible extent. And with this regard, following the international standards would definitely do their work. So I put the illustration, I put the cover of the last report on violation of human rights in Ukraine with relation to Ukrainian and Russian prisoners of wars. Although we can have some objections to applying the same measures to those who came to Ukraine uninvited as invaders, and to the treatment of those prisoners who are victims of the aggression. But in the eyes of international community, any violation of the internationally recognized rules will be, of course, noticed and underlined. So Yes, please go to the next slide, Anna. So the first most common problems that that we are dealing with when a piece of digital evidence is introduced by the party is authentication. And what I understand by authentication, there are many definitions of this quality. Authentication basically tells us that what the party presents is what he or she says it depicts, it illustrates. And reliability and probative value is another matter. For example, recording from CCTV is first has to be authenticated. Just first we have to know where it comes from. We must be sure that when it was recorded, we must be sure that it was not altered in any way, because today, alteration, forgery of electronic evidence is, of course, very easy. Then we, judges, we decide if it has any probative value for us. If, for example, persons depicted in the footage are really the defendants that we are having in front of us in a courtroom. So the first method is, which is internationally recognized and which is followed in international courts and almost in all jurisdictions in the world, is the use of a testimony of a witness who's telling us how the piece of evidence was produced. It could be an author of the recordings, or it could be a person who is depicted in the material, or it could be a person who has a knowledge, first-hand knowledge on the production of the material. So this we are very lucky if actually a piece of evidence that we are getting could be authenticated by this so-called pictorial testimony. That means this descriptive testimony by a witness who is describing how it was made and what is actually presented there. But very often it's enough to resort to the doctrine of a silent witness. That means silent witness theory is a theory that allows us to authenticate a piece of evidence, piece of digital recording on the basis of the knowledge of the process, how this material is obtained. For example, a witness, an operator of the CCTV camera system, can tell us how the system works, how the recordings are stored, how the recordings were preserved and found its way to the court. So the witness is not really telling us about the particular piece of recording, not really telling us what is depicted in the video material, but he's telling us about the method, how it was recorded. Very often, this silent witness theory is applicable to materials recorded by recognized press reporters. They record, and it's unlikely that they remember everything what they recorded. But the way they operate guarantees that or may guarantee, if we trust them, that the video material is authentic. Of course, we can resort to analysis of metadata. It's that's a set of information which is usually embedded into the electronic file, and it's invisible, but it's telling us very often when the material was recorded, time, also location, also the device that was used. We can compare this metadata with the statement of the witness, and in case of any discrepancies, it can raise our doubts. And of course, we can also request forensic analysis of the image, photograph, video recording, or audio recording. Very sophisticated technology can be used, and although you know, today to forge photography or even produce a deep fake, so-called deep fake recording, you know, is quite easy, even without any specialist training. It is also very easy detectable, because some analysis of shadows on a picture can prove that the image was altered. Next. Yes, thank you very much. When in Kosovo, we were very often confronted with complaints related to deficiencies in identification of suspects based on images published in the media. So it was common that, you know, the image of the culprit was presented in the media, and then people were who recognized the suspect were reporting to the prosecution, and they were used as witnesses. You know, usually the first occasion that they could see the suspect in person was in the courtroom, and it was called so-called in-doc identification. And of course, this is very far for what our judicial experience tells us about proper identification. The whole theory of police lineup, police parade, the theory of you know, of arrangements for the lineup has been developed in the 90s, when DNA analysis has proven that very often eyewitness identification was erroneous. You know, I've seen people on a death row in Chicago who were exonerated just after the DNA technology became so advanced that you know, the samples from the crime scene could be tested and excluded them as perpetrators. So eyewitness identification is as a sole and decisive evidence could be erroneous. We all know it. But you know, very often what we are dealing with is contamination of the eyewitness recognition. Yes, the witness recognized the witness, recognize the culprit or the suspect, and then the suspect is so many times presented in the media that in-person identification makes no sense. Because the witness is in fact recognizing the person that he or she saw in the media on the picture. And in Kosovo, we had situations that were hard to believe. For example, we had a female witness testifying that she recognized the suspect during the defendant during at the crime scene during the summary execution, that her members of family were killed because she worked with him in the same office for 2 years. So she was sure that she recognized him from during the critical time, and later on when she saw his picture in the press article saying that he was just arrested, she decided to report the crime. And it turned out that the age difference between them was 12 years. When she worked in the office that she referred to, she was only 20. And our defendant was only 8. So that's for sure it was not the same person. But the impact of this contamination by media was so strong that she simply rejected any reasonable argumentation that she could make, that she could have made a mistake. So please, next slide, Anna. What was very common in Kosovo were pictures of perpetrators taken during a very dynamic situation. And of course, the time of crime, that crimes were committed, it was 1999. So the technology was very poor, the quality was very poor. Very often we had images and we had resort to some forensic methods to recognize, to confirm recognition, identification of the person from the picture, just to make sure that we have a right person as defendants in the courtroom. And sometimes the witness presented the picture and was telling us, I knew the perpetrator for 20 years and I'm absolutely sure that he is the one on the picture. We resorted, of course, to eyewitness identification. That in that case, you know, if this acquaintance with the subject, with the suspect was long-lasting, the eyewitness identification could be very convincing. But we also tried forensic anthropometry. That means measuring of the length of the limbs know that there are old methods originating from 19th century, which give us never more than, I would say, 90% of accuracy, because it is possible that there are persons of identical dimensions. And the vulnerability of this anthropometric method was discovered only in the end of 20th century when big data analysis of big data was applied to check reliability of the method. So we must be sure that this anthropometry measuring of the length of limbs and proportions of the body could be very misleading also, although this is very strong circumstantial evidence. And the newest development is, of course, automated face recognition. This is technology which is acclaimed to be 100%, almost 100% accurate. Although it is not scientifically proven yet. So Anna, could you please go to the next slide? And then we are coming to the very serious dilemma, moral and legal dilemma, which is related to the use of automated face recognition in Ukraine. Some time ago, a company named Clearview donated to the Ukrainian Ministry of Defense the license, the right to use the technology, and also donated the access to database of faces of Russian people connected mostly from social media, mostly from services like Vkontakte or Facebook, Odnoklassniki. So almost at the same time, the Clearview was the use of the Clearview database was banned by the courts in the United Kingdom because of the European approach to protection of personal data. So any case when Ukrainian investigation is based on this automated face recognition could actually face serious challenge when the judgment would have to be recognized in the Western world. So we have to remember that this face recognition, could not be a sole and decisive piece of evidence when it comes to determination of the guilt. But it's very important to keep in mind what Professor Chan presented us about admissibility of evidence in international courts. You see this doctrine of the fruit of the poisonous trees, which is present in Ukrainian jurisprudence. I follow some rulings of the Supreme Court, Ukrainian Supreme Court before the aggression. So it was not that uncritically applicable in Ukraine, but it was definitely observed. So I don't think this is a big problem for the fairness of the proceedings. But as I said, this recognition of the witness must be very well. Identification of the suspect must be very well proven. Yeah, please move to the next slide, Anna. What may happen, what I guess that may happen, and what actually happened in Kosovo was admissibility of unauthorized recording. And you know, in Kosovo there was no this doctrine of the fruit of the poisonous tree. I mean, the law, the rules of criminal procedure did not prohibit, you know, using of illegally obtained evidence. Although there were very strict restrictions in this regard as well. But you know, I saw international judges automatically applying their understanding of the fruit of the poisonous tree doctrine and excluding admissibility of such evidence. You know, I will save you hearing this recording of the Russian woman instigating her partner, as I understand, or husband, to commit sex crimes against Ukrainian women. It is drastic, but I think we all know about what I'm talking about. Of course, this what the woman did is instigation to war crimes. I think it would be enough to issue an international arrest warrant for her. I think I would sign such a warrant if the motion came to me. But you know, the question is legality of wiretapping, legality of recording. I have no doubts that wiretapping, eavesdropping of invaders, of their communication is absolutely falls into the rights of defense. I mean, the country that defends itself from aggression has the right to listen to private conversations of the invaders. That's for sure. This is a war necessity, I would say. But what about the civilians that are interlocutors of the invaders? I think that this also needs some decision and some legal reasoning. I would say that, you know, the person that is talking with a soldier in a foreign territory should be aware that the conversation is wiretapped, and that means that such a person exposes herself voluntarily to such a risk. And in that case, you know, what is knowingly exposed to public cannot expect protection of privacy. So this would be my practical solution in this short case study that I let myself to present to you just now. So this is the last problem that I want to present that we faced in Kosovo, and unfortunately some international judges took a bite. You know, this copyrighted materials from internet. Anytime we had video from YouTube presenting you know, presenting the criminals actually, or soldiers that were present at the crime scene. You know, we had a motion from the defense lawyer to exclude it because we don't know, we have no consent of the author, and this is unauthorized use of copyrighted materials. Of course, the copyright protection in Europe, in most of European countries, is automatic. Although in Ukraine, I know that copyrights must be registered. Also, automatic copyright protection is also present. But you know, how can you deal with such a argumentation? Very simple. You know, copyright protection of copyrights aims against, you know, alteration of the unauthorized alteration of the work, against infringement of monetary rights of the author, but you know, in no way the presentation of the work, of piece of work in the court falls into any of these categories. So both in European system, Berne, saved on the Berne Convention from 1886, and of course also on the American protection of copyrights, which differs significantly from the European system. The use of copyrighted materials published on the net for evidentiary purpose does not need any permission from the author or from the internet service provider, so internet publisher. It might be an issue to get metadata of the piece of recording published, for example, on YouTube, or then of course a court order could be issued to present such data when the material was uploaded, for example, from which location, etc. But you know, when it comes to materials published, for example, Contactie, I don't believe such an order would make much sense. But anyway, such a piece of evidence could not be excluded because it can be authenticated. It could be authenticated by you know, the methods that I have already presented. So it concludes my presentation. This was more just to stimulate, you know, your attention to the problems that can appear while dealing with electronic evidence. I'm sure that Ukrainian judges will always find a right solution. I think you are excellently prepared to deal with challenges that the new technologies bring. Thank you very much.
Дуже дякую, Dariusz.
Thank you, Dariusz, for your presentation and especially for sharing your experience of working in the international courts and about the experience of different countries that the judges have to deal with challenges in this respect. And also, I think that it is very important that you've emphasized the importance of Ukrainian courts and judges doing everything possible that all defendants have the right to a fair trial. And I think that we should emphasize that the entire world is watching Ukraine. Everyone will evaluate what's happening in Ukraine, and everything that is done by the court system in Ukraine is also important.
I let myself one final comment. Sorry for apologies for interrupting you, Anna, but you know, when I was looking for answers on admissibility of evidence in various tribunals, international courts, you know, I did my research and not to say nice things, but what I found were just work by Professor Krzan. This was my first encounter with Professor Krzan. I think that it would be very useful for Ukrainian colleagues to have his work translated into Ukrainian language, as well as Anna, your book. I think we in Kosovo, we international judges, we could avoid so many mistakes if, you know, this knowledge would be accessible to us. And you know, international judges, they consider these international evidentiary standards as some kind of fetish that they heard about, but they didn't really understand. That's a very sad constatation. So I think maybe Prawo Justice could you know, take this task to of course if Professor would agree, if you would agree to make your experience, your knowledge available to Ukrainian colleagues. Thank you very much.
Дуже дякую, Дар'юш.
Thank you very much, Dariusz. This was an advertisement as well. I would like to say that we had a question about the book, and I've shared the title of that book. That is Philip Sand's book, East West Street. I don't know whether it has been translated into Ukrainian. I don't know, but this is a very interesting book. And on the one hand, it is about the law, about international law. But on the other hand, it also has this historical and humanitarian aspect. Yes.
I will be speaking English now because I will give the floor to our last speaker today, Klaus Hoffmann, who is the prosecutor from Germany. He's a member of the Atrocity Crime Advisory Group, the group of international experts that is helping the Office of Prosecutor General of Ukraine to deal with atrocity crimes committed in Ukraine. He has also had experience of working in the International Criminal Tribunal for former Yugoslavia, and we would be happy to hear from you your observations as a prosecutor about the admissibility of evidence.
Thank you so much, Anna. It's a pleasure and an honor to join you all this evening and tonight. I'm also aware of the time, and I know all those in Ukraine, it's an hour later, so I'll try to be brief. Just maybe as a first point or background, I'm actually sitting, I'm just coming from Kiev, where I spent the last 2-3 weeks. I'm actually now here in Berlin in the Ministry of Justice, where we do have a workshop with 10 Ukrainian prosecutors from the OPG and 2 colleagues from the Ministry of Justice, working on war crimes cases and international cooperation. But having said that, I'll be very brief, actually, because my previous speakers have touched upon so many issues already, so that makes it a bit easier for me to be brief. I did indeed spend 5 years at the ICTY in The Hague, working on war crimes cases, mainly against Serbian perpetrators. And in a nutshell, I can say that initially the rules of procedure and evidence were mainly common law driven, as the statute and the rules of procedure and evidence to my knowledge, were mainly drafted by the American Bar Association at the time. So it had a very strong common law influence. Me coming from a civil law country background, did have some issues in the beginning to understand some of the common law rules and some of the proceedings. But I would like to say that over time, the judges of the ICTY in the plenary had the possibility to adopt those rules of procedure and evidence. So if you ever Google the rules of procedure and evidence, you will see that basically every year those rules had been adopted. So from a very strict common law approach, it moved slightly to some hybrid solution. And as we've heard before, in Rule 89 of the ICTY Rules of Procedure and Evidence, there's a very broad rule that allows basically for any evidence that has probative value. What we've seen in the beginning, and I witnessed even as a very junior intern at an earlier stage at the ICTY proceedings, where the presiding judge very much in a common law fashion would not dare to ask any question to the witness, but rather turn to the prosecution, asking the prosecution or indicating that the prosecution might ask another question to the witness, which to me as a civil law prosecutor was very odd. But over time, both common law judges and civil law judges have changed their mind, and they have changed the rules. In a nutshell, not only did those judges ask more and more questions, but also in the rules you had suddenly what they called chamber witnesses. So not only witnesses called by the prosecution or by the defense, but basically in every later trial, the chamber itself would call witnesses. Generally, the ICTY applied a very flexible way, I would say, and I'm very happy with that approach. And one would have to distinguish between the pure admission of evidence and the probative value. And we were very much in favor and pushing judges to rather have evidence admitted into evidence and later then in the context of the overall collection of evidence to assess a probative value, rather than to have a very strict or very high threshold when it comes to the pure admission of evidence. But yeah, as I said, that was mainly the approach of the chambers, that they were rather in favor of admitting evidence, and then later when it came to the judgment, to assess the value of that evidence. Authenticity was already raised. I just make a few short comments maybe, and again from a practical point of view, both from the tribunal as well as my 20 years of experience as a prosecutor and judge in Germany. I do agree that we have to be very careful about the authenticity and to make sure that the chain of custody is preserved, that it's clear from the outset how some certain evidence was secured and preserved. But the comment that I would like to make is that in many instances in practical trial experience, you often have so much corroboration and different evidence that some of the theoretical problems we see in the beginning don't really play out. Because even if there's a video where there might be some concern about the authenticity, at the end of the day, you may have another 3 or 4 witnesses talking about the same event that is described in the video. You may have some documentary evidence on top. And if you put that all together, it's going to be much more difficult to question the authenticity of the video. I do have lately visited a crime scene at Hostomel outside of Kiev, and I've seen several videotapes or video footage from the crime scene, from the shooting of civilians there. And what I want to stress here is, and that would be not an issue at the ICTY at all, you would have video footage from different angles, from different cameras. I've seen those videos, but I've also seen the testimony of a number of witnesses. I've seen documentary evidence. I've seen crime scene evidence on the ground from the weapons and the like. In that instance, I hardly foresee that at a later stage there will be a big point to make by any defense to question of one of the authenticity of one of those videos because it's just one part of a larger puzzle of evidence. So yes, we have to be careful, but at the same time, in many instances, it's not the only piece of evidence, and that does help a lot as well. What we've done at the ICTY, and which is probably also too obvious, but when it came, for example, to documentary evidence, we made sure that very early the documents were preserved in its original, and all investigators would work with copies. So you could even at a later stage maybe go back to the original and take fingerprints or DNA testing to show that somebody actually had his fingers on this particular document. So we always try to work with scans or copies of documents and preserve the original somewhere else. One example were the war diaries of General Mladic that were found at a very late stage, but those were crucial documents, and of course they were treated with big care and then scanned, and all of us prosecutors and investigators would only work with the scans and of course not with the original. But I think that's almost too obvious to most of you. Just one quick addition of maybe on electronic evidence, that's of course becoming much more important in these days. If I remember our times at the ICTY, of course there was hardly any civilian that would run around with there were no mobile phones to take pictures of Russian or Serbian tanks in that case, or to take videos. So in that sense, the current war is very well documented. But of course, it also brings those challenges that were mentioned before. At the same time, I must say that I've already seen a number of IT solutions, including some of the apps that can be used by civilians in Ukraine that do preserve the metadata at a very high quality. So if a civilian on the streets of Bucha uses one of these apps and takes a video of the Russian tanks running through the city, the original metadata is immediately preserved and cannot be altered. So if that video has been provided to the SBU at some time, you can always go back and say exactly when that video was taken by which camera at which geolocation. So in that sense, I'm rather optimistic that we can preserve the best and authentic evidence in that case. There was maybe one last comment, because I think one of the previous speakers also said, of course, we are presenting the evidence to professional judges, and that will be, of course, the case in Ukraine. Just a little critical comment on what we experienced at the ICTY, and I must say, not all of the judges that were present or presiding over the cases were actually professional judges. The international community decided to accept diplomats as judges, former defense counsels, which sometimes stayed in their role as defense counsels. And we did have a number of lawyers who had practically no experience in any big cases. That caused much more problems than anything else, I must say, unfortunately. Yeah, looking at the time, maybe I really love to leave more time for questions and discussions, and open the floor for that, and maybe leave it at that for the moment. Thank you, Anna.
Thank you very much, Claire. Thanks for your comments. Very, very practical. And I think that one of the main challenges that is being faced by Ukrainian prosecution is like overwhelming amount of the evidence, also the electronic evidence, and the need to analyze it. In this sense, the war in Ukraine is one of the best documented war ever, because actually, as you have mentioned, everybody now has a camera, has an apparat, etc., and everybody is trying to record what is happening. And you know, you also made this very interesting point. You know, when it comes to ICTY and other international courts, these are judges who develop the rules of procedure, rules of evidence, so they make it more practical, more based on experience, and perhaps it also helps. Of course, we cannot imagine that judges in Ukraine or in any country would adopt the rules of evidence, but perhaps, you know, this involvement of judges and professionals, generally prosecutors also, in developing procedural rules to be applied would be of value. And you know, I also, like, from my experience, also from Kosovo. Kosovo was very specific because the criminal procedure code was developed to a big extent by Americans. So there was this impact on American procedure on it quite big. Including these questions of admissibility of the evidence, cross-examination, and other things. But what was very interesting, it was working with American judges on the panel who did not believe, or who did not want to accept, that they as judges can put questions to witnesses, because in their legal system it's just not allowed. And you know, they even did not care about the Criminal Procedure Code of Kosovo, where it was strictly written that a judge is allowed to put a question, but it was so far from their culture that it was, yeah, for some of them was really not acceptable.